Welcome back to the Entreprenudist Podcast. This is episode 2. This is episode 2 of the Entreprenudist Podcast. Today, I am interviewing a special guest by the name of John Wood. John Wood is a published author. John Wood is an attorney. John Wood is an educator. Now, what did I promise you when I introduced you to the Entreprenudist Podcast? I promised you interviews with multi-millionaire business owners and entrepreneurs. Now, have I ever asked John what his net worth is? No. But I know math. All right, so let's talk about this, okay? So, like I said, John is a named partner with Green Klein and Wood. Green Klein and Wood handles first-party property loss claims. From what I know, they typically don't take any claims where the dispute is less than 6 figures on up to multi-million dollars. Now, the way a lot of attorneys work is they work off contingency. How does that benefit the client? It benefits the client because a lot of these claims can take months up to years in order to reach a legal remedy. If you were paying an attorney based off their hourly rate, there probably wouldn't even be any money left over. But when an attorney works off a contingency, what that means is they don't get paid unless you get paid. And attorneys typically want anywhere from 30 to 40%, depending on if things are handled swiftly, get settled, or they have to go to trial. So if you work with and are a managing partner of a firm that only deals with 6 figures and up, multi-million dollar claims, and you have a 30 to 40% contingency, I have no idea what the percentage is, what they're working with over there, but that's typical, 30 to 40%. And you're doing hundreds of these claims, and you respectfully excuse your Aunt Sally and you carry the one, what do you get? Exactly. Here's my interview with published author, attorney, and educator, John Wood. John Wood, attorney John Wood, thank you so much for joining me today.
My pleasure.
Oh, man. And you're the first attorney that I've interviewed, so it only makes sense that when I sent you my interview release agreement that you had a requested change.
Oh, yeah. That's one of the things you pick up, that behavior of not just signing things without reading it first.
Absolutely. Great lesson. And what they try to, because where I got that release agreement is from a business law course for podcasters. And they try to tell you to read all of the terms and agreements of all of these websites that we use to aggregate and things of that nature. And I'm thinking, I wonder if there's somebody actually doing that. Because I think they just tell you as a disclaimer, hey, just read it. Read those 13 pages of terms and conditions. But yeah, it's all good.
Yeah, exactly. Nobody reads the end user license agreement.
Oh, man.
And if they do, they don't understand it.
And if you don't read it, you got a good attorney. They can make a legal defense for you. Nobody reads these things, Judge. You're right. You're right, Mr. Wood. Nobody. All right, but thank you so much, man. So the reason why I brought you on is I see an attorney more so as a entrepreneur than anything. Do you agree or disagree with that?
I think it really depends. There are sort of two main camps within the practice of law. There are the big law career types, and then there's the entrepreneurial lawyers. And I suppose there are some entrepreneurial leaders within the big law firms, but those are more institutions that have been around for 100 years or for half a century, and they have existing relationships, and so they can be much more conservative. However, the law does allow for entrepreneurial innovation, and some of the most successful attorneys out there have been innovators, and they've taken risks, and they've been creative, and they've solved big problems.
So when you say entrepreneurial innovation, and they've taken risk and solved big problems, does that mean they came up with unique legal defenses? And if not defense, is there a such term as legal offense?
Yes. So it's not just offense and defense, although those are definitely the case in an adversarial setting where you're suing people or you're being sued. It very much is a matter of tactics and strategy, and all the war game metaphors apply.
Mm-hmm.
But the law is more than just litigation or criminal defense and criminal prosecution or civil litigation, breach of contract and torts and things like that. The law is also transactional. In fact, I would say the law touches every aspect of life, from birth till death and everything in between. And so the role of attorneys is more than just fighters, although that's popularly how we're conceived in our when somebody says, I'm going to get an attorney, they mean they're about to go to battle and they're going to lawyer up. However, we are problem solvers. And I encourage people to think of their relationship with attorneys more as a counselor than as a hired gun. Mm-hmm. Because a lot of our problems can be solved by changing your behavior and changing the way you communicate, and they don't necessarily require going to court and filing a lawsuit and having a judge adjudicate the party's rights. In fact, I'd say that's usually the last thing you want to do. And as an attorney, that's usually the last thing we do, is actually go to litigation. We look at that similarly as performing a surgery in a medical context. If there are things you can do to heal before going under the knife, you should probably try and do those lesser invasive, less risky things. And so I look at lawyers as problem solvers more than fighters. And so in the transactional setting, we put deals together. We settle conflicts. We find a way to find out the underlying sources and causes of conflicts that the parties themselves might not even be aware of, and we can alleviate the underlying issues. And now people go from enemies to friends, strategic alliance instead of competition. So it really depends. I mean, I think that a lot of artificial intelligence studies would define intelligence in a computer system in terms of problem solving. And I think it's actually a pretty fair general definition of intelligence, is the ability to solve problems. And at the end of the day, when people talk to an attorney, what they need is wisdom. What they need is somebody that isn't going to have an irrational response. They're going to think about the issues clearly and give good advice that's tailored in the long-term self-interest of the person receiving that advice. That simply means sound problem solving. And I think that's what people expect of their attorneys. And that's why the smarter you are as a lawyer, the more successful you're going to be in terms of your ability to solve problems for people.
Yeah, because I heard you say a problem solver most of the time, but it sounds like you're advocating for problem prevention. Do you believe there's a difference?
Yes, there is a difference between solving a problem and preventing one. And entrepreneurs should, or anybody managing their own family affairs or a business, should be trying to prevent problems proactively if you can. You're going to spend less,
and you usually
you're going to spend less time and resources.
And you usually can.
Some of them are. Yeah, that's right. Most risks are avoidable if you're thinking through, you're surveilling your environment, and you're accurately weighing risks. Then you can prevent a lot of things. And an ounce of prevention is better than a pound of cure. And a lot of times, it's management problems. It's a failure to manage risk effectively that leads to a legal problem, and then you are forced into litigation. And now you're trying to cure a disease instead of avoiding ever contracting that disease.
Yeah, because I know cure is a term, and I'm definitely going to get into what motivated you to get where you're at. But I know cure
Yeah.
is a legal term. But I just heard you associate it with what you would think to associate it with a biological cure. In your
hmm
studies, is that the way your instructors conveyed it to you and your colleagues or your class? All right, think of a legal cure as curing a disease.
Actually, no. That's just how I approach it. I think analogically, and the law does too. We use analogies and metaphors, and as a writer and a poet, I think metaphorically a lot. But I am often drawn to the analogy of law as like it's a practice of law, like there is a practice of medicine. It's not a perfect analogy because there are really important differences, namely the adversarial nature of law you don't get in medicine. There is no doctor that's trying to make you sick.
Well,
Whereas there is
at
an
least
opposing.
unless you're wearing a tin hat, right? But go
Yeah,
ahead.
right, exactly. But yeah, like doctors are all trying to heal everybody. The first oath is do no harm. Whereas attorneys, if that's the opposing counsel, you should not talk to that person. Everything you say is going to be used against you. They're looking to find fault. So, that's the main difference between law and medicine in terms of how the public reacts with us and interacts with us. But I think that the analogy is pretty good because one, we have a fiduciary duty to our clients.
Mm-hmm.
We have to put your interests ahead of our own. So a doctor and a lawyer can't say you should do X because it benefits them.
Mm-hmm.
It has to be in the right interest of the client. It has to be in their interest. Another thing is that it's a learned profession. You have to know a lot in order to competently practice. Three, it's self-policing. There's a bar exam. There's a licensing requirements for both doctors and attorneys. It's an ongoing learning requirements, and it's self-policing to maintain the highest standards of professionalism. Requires practice, and it's an art as well as a science. So there's a lot of analogies between the practice of law and the practice of medicine. But I think that from a business owner's perspective, you want to try and prevent a lot of risks if you can. Some of them are unavoidable, and it's just a question of how well do you manage that. I would encourage entrepreneurs to consult with an attorney about your prospective hypothetical conduct before you go down that path. Talk it through, forecast what the risks and benefits are, compare different strategies, go through your decision tree, and then make that decision based on sound legal counsel. And there you will avoid a lot of risks instead of going down that path, getting into a legal problem, and now you have to go to court and sue and hope that you win, where your fate is in the hand of the judge and the jury. You can have the best lawyer in the world, but if the facts aren't on your side, there's only so much you can do with legal resources. And a lot of problems between, bitter litigants that didn't want to talk things through and solve things informally. The only people that win in those conflicts are the attorneys for both sides. They're the ones getting paid. And the business owners just keep shelling out money to their litigators until they get tired of it and then they settle.
Absolutely, because even whether it's problem prevention or problem solving, I do recommend that people involve an attorney. One of the ways that I recommend people involve an attorney, and let me know if you agree with this recommendation or not, is I say, hey, it's two ways you can go about this. And usually I have this conversation with people who have partnerships. I say, hey, either A, you guys can go to an attorney and get them to draw up a custom partnership agreement, and that's going to cost whatever it costs, usually at a premium because you're essentially asking for something new that didn't exist before. Or B, you can pull up a form off online and then pay an attorney to review that form. It seems as if, and this is just a layperson's perspective, it seems as if you would essentially get the same benefit, except it's usually less expensive for an attorney to review a document as to prepare a completely new one. Do you agree with that course of action, or do you have some horror stories?
Well, yeah, I think that's a reasonable thing to do with certain standard forms. They will be pretty common, like a general LLC, member managed LLC, or a standard purchase and sale agreement. They tend to not change much from time to time. However, you might have, say in a business partnership, a very unique situation that you need to be custom tailored to you. I would definitely discourage using online forms and then trying to tweak them on your own and then enter into them without getting legal counsel on that at some point. You're very likely to make a mistake there and to end up committing yourself to things you didn't understand or wouldn't have agreed to had you understood it. So don't do this without legal counsel, but with reasonably sophisticated business parties, you should be able to take a standard form on the internet, read it, understand most of it, add your custom terms, and then go take that to an attorney, a business lawyer, and ask them if the form that you used is the right one, and also if the terms that you wrote into it are correct and would actually carry out the effect that you intended, and then get that lawyer to essentially give you the last edit and to say, this is this is what you actually want. And there can be some revising and some feedback necessary. And don't be surprised if it takes you a few hours of attorney time to get that document into the right shape. But if your formation or partnership agreements are flawed, it can cost a fortune.
Mm-hmm.
So I think it's a reasonable spend to make sure that you set it up correctly on the front end versus, going down a path, realizing there's liabilities you didn't anticipate, and then you're stuck with a form that actually allocates that risk to you, unbeknownst to you.
Very reasonable. And that actually brings me into my next question. I heard you mention specifically business lawyer. A lot of people, when they think of an attorney or a lawyer, they think, all right, no matter what legal problem I have, this attorney that handled my speeding ticket can also handle the formation of my business. So first, what type of law do you practice or prefer, and what type of credentials should a business a lawyer have that maybe an entrepreneur or a business owner listening now might want to ask or look for?
Well, I would say, first of all, you definitely do not want to treat a lawyer as the one-all, sort of end-all, be-all solution to all of your legal solutions, just like you would not with
what do they call that? A panacea? Is that the word?
Yeah. We're specialists, okay? And now you might find a law firm that is a general services firm because they have a specialist from every corner of the law. But just like in medicine, if you broke your leg, you're not going to go see an ear, nose, and throat doctor, right? You go see a sports doctor that can do that surgery, that can heal you. If you've got an eye problem, you don't want to go see a gastro specialist that's good at gut health. All right, you want to go to the specialist that just does that area of law. And so for me, I pay my bills by suing insurance companies that failed to pay out when their insurance policies were implicated in a loss. So when there's been a breach of the insurance policy, when there's bad faith insurance claims handling, we come in and we sue the insurance company on behalf of the policyholder, and we make them pay. And that's all we do. All we do is sue insurance companies. And that's why we're good at it, is because we have the pattern recognition, and we've seen every different permutation, every kind of offensive and defensive maneuvering that the carriers try and do. We've seen it all. We have a plan of attack for whatever they do. Now, if we got into an estate planning matter, we're going to be way out over our skis. It's not our forte. We don't regularly do probate issues. We're going to have to be consulting with outside lawyers all the time to figure out what's going on. Now, technically, an attorney can make themselves competent by study or by associating with another attorney who is a specialist. And that's the only way ethically that it would be permissible for a lawyer to take on a representation that they're not exactly familiar with, is to associate with another lawyer that does. And we should be generalists enough. And that's one of the purposes of law school and the bar exam, is to say, at the very least, we should be able to spot issues. So if you came to me with a hit and run issue, or you came to me with a business formation issue, or you came to me with an estate planning problem, I would be able to at least identify the legal issues and the factual issues that case would turn on. And then I can refer you to a specialist that can deal with that. But you would have been better off having talked to any lawyer at all versus no lawyer, because at least they could have apprised you of what the issues are going to be. But then you want to go see a specialist.
So I mean, that is what I consider, and I think most people consider the definition of a skilled practitioner or a professional is not necessarily knowing everything, but knowing where to find it easily.
Mm-hmm. Exactly. Yeah. And just sort of a general problem solving. I try to be resourceful for my clients. And I mean, if I can't solve your problem, I'm not going to beat myself up about it. I'm just going to find somebody that can, and at least steer you in the right direction. But I would tell folks, entrepreneurs should have a general business counsel. And that is somebody who's something of a generalist, but their specialty is still within business entities, business formation, contracting, especially because for a lot of entrepreneurs, that will make or break your business, is how intelligent are your contracts? Yeah. Because that's what's assuring your income. That's how you get the money. That's how you protect yourself and disclaim things. That's where your warranties are. That really affects your success. And so have a contracts lawyer at the very least that can draft your agreements for you. And then if somebody breaches your agreement and they refuse to pay you, you have a lawyer already retained. It's familiar with your business, and they can go handle collections, or they can go file a lawsuit. And this, if you're lucky, this same lawyer will have other attorneys in their firm that can also help you with HR issues. So you have a disgruntled employee, say you've got OSHA compliance issue, or say you've got a regulatory permit that you need guidance to get this permit. Those are the kind of legal services that entrepreneurs need. And I highly recommend entrepreneurs to become legally astute. Understand the law as it affects you. You don't have to understand all of the law, but just the key legal issues that affect you. And that's just part of your operating environment. Just like you need to know your product, you need to know your competition. You also need to know the laws that, if any, that affect your business.
Oh, yeah, absolutely. Because I know one of the things that I think might affect a lot of entrepreneurs that, unbeknownst to them, is I know a lot of people are using 1099 employees, right? And, one of the benefit of having a 1099 contractor from, my perspective is you're not required to have to do a lot of the obligations that someone who has employees, such as, what's the word? I can't think of it. The things that you have to pay because you are actually you have employees, like different fees, different taxes. But one thing that I learned with one of the courses that I took, which was a course that was provided by an attorney, is a lot of people don't realize as soon as you start guiding your 1099 of what to do, instead of just giving them a goal and letting them accomplish it the way they accomplish it, as soon as you start guiding them, they essentially become your employee, and the liabilities follow along with it, potential liabilities. Have you ever ran into that?
Yeah, I mean, it basically comes down to this old saying that no good deed goes unpunished. You have to be careful when you're undertaking to give advice or to help people, or to because if you're giving them instruction and they're carrying out your orders, they're not an independent contractor. Mm-hmm. I mean, I'm not an employment lawyer, but if they're basically depending on you for work orders and they're not free to exercise their own judgment, and you're just helping them out, right? You're probably making them a de facto employee. Mm-hmm. And that means you should be withholding taxes and otherwise treating them like a W-2. But you have to be careful trying to help people because once you start, you can create expectations. You can create legal duties. I mean, for an attorney, if I start giving advice to people without adequate disclaimers, I could inadvertently create an attorney-client relationship with them,
Uh-huh. Oh yeah, now you
right?
good.
And so,
We share some of the same forums, and you're great at giving disclaimers. Let me tell you. Absolutely. And you even warn people because I've gotten into that sense to where you want to help people so much online because you remember where you were when you started in this industry, but then at the
mhm.
same time, like you said, you open yourself up. So I've gotten into the practice, and I don't even know how effective this is or not, but I'll be like, in general, that like before I say
Yeah,
anything, in general, and then I
yeah,
go, and then at least I feel like it gives me some. All right, I'm not talking about you specifically, but generally.
yeah. That's right. I mean, that exactly. I mean, almost every answer to a legal question starts with "it depends." Right? It depends on the facts, and if you change the facts around just a little bit, it could totally change the legal analysis.
Man, I paid.
So,
I didn't mean to interrupt you because as soon as you said that, it brought back a bad memory. Go ahead.
yeah, I mean, that's why we speak in hypotheticals, and in law school they train you in hypotheticals, and they'll ask you, you know, Rand man, if this is the fact pattern, what's your conclusion? And then they change the fact a little bit, and they say, well, what if instead of veering into oncoming traffic, they just hit the brakes?
Mm.
And then you have to go through the analysis again, and it trains you to not get wedded to a prior decision or an outcome, but to actually follow the facts where they lead and to deduce the implications of those facts in a logical, dispassionate manner, and to be able to change gears quickly mentally. And that's just a skill set that you need to practice law. And so they use that method in the classroom, and the Socratic method and using hypothetical situations. It's a really good mental gymnastics.
Uh-huh.
It helps you to think logically and clearly and rigorously. That helps in life in general. But yeah, it depends. Get used to saying that
Hey, man,
because Mhm.
let me tell you this story. I actually paid for a course, right? And one of the benefits of this course is that we're going to have a Q&A with a practicing attorney, right? And I promise you, there had to be at least 20 questions asked of this attorney, specific. And you guess what his answer was to every one of them?
It
It
depends.
depends. Oh my God. I wanted to walk out of
Yeah.
there. I like
Uh-huh.
it's one thing to say it depends and then go in general and then give what you think, right? But his it depends, period.
Oh, well, that's not legal advice. Yeah. I mean, that's just a truism.
Okay, got it. So, all right. So, I'm glad you gave me this time to get in because I know I want to get to how you got to where you are now and how you normally come into contact with business owners is when you look at the policy that they actually purchase, right?
Hmm.
And then and like you said, it doesn't matter how good your attorney is. It depends on the available facts. And believe it or not, folks, your insurance policy is a contract. They might not call it a contract, but it's a contract. You had a meeting of the minds. There was consideration. You agreed to pay the premium. They agreed to cover you if something happened. All of the elements of a contract are there. So if the contract that you sign with them doesn't give my man John Wood enough work to chop off at, pun intended, then you'll be lost, right? So
Yeah.
what
If
was
it's
your
not covered, we can't go sue for it. You got to have something to make a claim against.
Absolutely. Or you can be one of those creative innovators that John mentioned to where you can come up with a new legal strategy that no one's ever heard of, like a affluenza or something like of that nature, and then win, right? So, John,
Yeah.
what was your first example of an attorney? And did you immediately say, I want to be an attorney, or did that gradually happen?
That's a great question. I think the first encounters with attorneys I had must have been in the movies. It was probably in, Time to Kill or some Grisham novel adapted for film.
Mm-hmm.
The Firm, I think everyone kind of has this sort of pop culture notion of what a lawyer is, but I never identified with them. At no point as a child did I think I want to be a lawyer. And in fact, every time I distinctly remember growing up, people saying, "What do you want to do? What do you want to be when you grow up?" And all of my friends had an answer. I want to be a vet. I want to be an astronaut. I want to do this. And I was always like, how am I supposed to know? I just got here. Like I'm still figuring this out. And yet all along, people, I guess starting in high school, my friends would trust me with their secrets. They would come to me when they were in a sticky situation and they'd ask for my advice. And I would keep their secrets and I would give them the best advice I could based on what would be good for them.
Mm-hmm.
And little did I know it at the time, but that's the essence of the practice of law.
Yeah.
Is keeping your client's information confidential and advocating for them and putting their interests ahead of yours as a fiduciary. And so, and as a student in college, I studied philosophy and literature. And so words and ideas and logic and making the best argument, that's basically a pre-law track of study. And still in undergraduate, I didn't know that I wanted to be a lawyer. And it really wasn't until, because I was like, I'm a writer and identified as a writer before anything.
Oh, that's the third.
I've been writing poetry.
I've been counting you, because you're definitely a published author. I say, I'm gonna count every time John tries to segue to that. We're on number 3, John.
Really?
I'm just messing with you though.
Already?
But yeah, we're on number 3. But I like that. But
yeah.
Go ahead. Okay, so all right. So you saw yourself.
Yeah,
as
I mean,
a writer.
words are our tool as attorneys. We move words around and they take on all sorts of special powers if they're put in the right way.
Man, the most powerful people of societies throughout history have been the poets. The most powerful.
The unacknowledged legislators of mankind are the poets.
Even today, because when you look up the broad definition of poetry, right, to create something and to enthusiastically convey it, still the most powerful people in the world are poets. The speech writers, the law writer. Law is poetry to attorneys.
Oh yeah, it can be. It can also be like reading the back of a cereal box.
Hey, that's just a bad poet, man.
That's right. Yeah, there's no reason it shouldn't be a beautiful, inspiring thing. I mean, read the Declaration of Independence and tell me if you don't get goosebumps.
Absolutely,
and that's the cornerstone of the U.S. Constitution. So yeah, and a well-reasoned judicial opinion ends up ringing for eternity. Practically, they get cited and cited because it's just the right way, the best way to put it. And so language is our craft. Language and logic, persuasion. And we build structures out of words. We build complicated transactions and business relationships, and investment vehicles and risk sharing vehicles and all sorts of policy instruments are just words on a page. So little did I know as a young man, I was training for a career as an attorney. And I didn't know up to my junior year probably in college that I wanted to be a lawyer. I still didn't know. I just wanted to be myself. I wanted to be the best version of myself that I could be. I wanted to have a big impact on the world because I wanted to help people. I wanted to be a light, to take what I learned and the things that I was especially good at and to try and help humanity with that. And that's pretty vague. And that's why I didn't know. But at some point I realized a PhD wasn't for me. It was too theoretical, too far removed from practice in the real world. And that a law degree just started to feel right. It started to feel like that's what was missing from my education was how does this society actually resolve disputes between people? How do we manage risk? Who's really in charge? What is the purpose of government and how do we make it better? I mean, those big philosophical questions actually drove me to law.
All right. So I know you mentioned up into your junior year. Do you remember the moment?
I remember knowing that I had to have plans for what came next, and that I could either start working, go get a job in corporate America, or I could continue my studies. And I knew that I wasn't done learning.
Mm.
And I knew that I would not be happy in the 9 to 5 job with 1 week of paid vacation. Like
Mm-hmm.
the idea of that just makes me feel like I'm in a cage.
Absolutely.
And that there wouldn't be enough room for creativity. And so I was at an inflection point where I essentially had to choose between a PhD and a law degree. I didn't do pre-med, and I don't like blood, so I couldn't be a doctor. I knew that a long time ago.
Mm-hmm.
But that's when I chose to sit for the LSAT. And when I first took the law school admissions test, I scored in the 50th percentile, and I thought to myself, I think I can do better than that. And so I'm a competitive person, so I started challenging myself. And a friend of mine was a tournament chess player, and I had him come to my apartment and just kick my butt in chess over and over again until I learned how to think analytically and tactically. Because I was such a creative thinker, I was a divergent thinker, and you needed to be a convergent analyzer to really excel in the critical reasoning test. And so I had to train my brain to think in terms that were being actually tested for and rewarded by that exam. And I gave myself a few months. I went monk, so to speak, where I was just extremely focused and disciplined, and had a regimen. I'd get up at this time every morning, go on a jog, have a breakfast, take practice exams. I wasn't socializing aside from my chess playing friend coming over. And I ended up scoring the 97th percentile. And I could wave into Mensa on that score. So you can do it.
So tell me that. All right. So that's interesting. Did you make that correlation yourself with the chess playing, or do people who think divergently, is it a known fact that if you want to switch to, I think the terms you use, convergent, that play chess, it'll get you right? Or did you just make that correlation yourself?
I just figured it out. I realized that the skill I had as a writer to come up with new expressions or using bigger and better words wasn't being rewarded at all. Being able to interpret something in many different ways, that wasn't being rewarded. What was being rewarded is sort of this plotting ability to get to the bottom of a logic problem.
Mm-hmm.
And that required focus. And so I just knew that what I was doing, what I was innately good at, wasn't working. It wasn't being rewarded. And so I had to retrain and learn to think differently. And it just required more discipline, really. And part of it, too, is just the ability to focus, because the test is several hours in a row where you just have to solve this problem and then, boom, move to the next problem. You can't linger. You can't beat yourself up over a question you didn't get. You just have to be really disciplined and keep moving forward.
Absolutely.
So I just needed to get disciplined. And that's one of the biggest factors of my success, is knowing when I'm not good enough for something, knowing when I'm not ready for a challenge, or when I'm likely to fail. And it's okay to fail when you're doing practice runs, but when certain things you approach in life, you have to have a failure is not an option attitude.
Oh, yeah. Reduce your chances of failure.
Exactly.
So when you do fail, it's something new that you can learn from. Failing from something that you could have easily got advice from an attorney to avoid, you don't really gain from that. I mean, you do, but
it's an unforced error.
Mm-hmm, there you go. All right, so boom, you take your LSAT. You in the 97% percentile. You can wave into Mensa, and by the way, I believe that's the you get like a pin, right? If you're in Mensa, right?
Yeah, I don't know if anyone does it anymore. It used to be a proxy for being really smart, but
I mean, go get your pin, John. Go get your pen, man.
Yeah, I should do it.
You
just
played 1,000
because,
games of chess. Go get your pen, man. And it'd be good to put on. It'd be good to put on your CV, man. It was actually an episode of Billionaires. I don't know if you watched that show, but the guy he was they found out that his Mensa pen was a counterfeit. So then, the compliance guy. Am I spoiling the season for you? Are you a fan of Billionaires?
I'm not up to
Billions?
date. I'm not, but it's
Billions,
great cast. Yeah, great cast, and I definitely want to watch it now.
Yeah, so the compliance guy, they found out that his pen was a counterfeit. So he had to prove that he was smart, but they knew his personality type, right? So this is one of the benefits of knowing personalities. They knew that if his ego, and I'm talking about the rest of the traders, they knew that if his ego took the hit to where he could not get this Mensa pen, that he would in turn crash everybody, right? He would in turn now start reporting the compliance issues. So they say, hey man, we got to do whatever it takes to help this guy's ego and get his Mensa pen back. And and so that was one of the storylines of that episode. All right. So
that's funny.
So you're 97th percentile. How do you choose your law school? How did you?
Oh man, so this was the fall of my senior year, and I had been basically I'd taken so many credit hours. I graduated with a double major. I had super close to getting a minor in multiple different studies. But just didn't get that last credit hour because I didn't have time, couldn't fit it in. And I was wrapping up my affairs at TCU, and I had applied to a long list of law schools that fit my profile as an applicant. And so I was basically shooting high. I had a 3.9 GPA, 3.98. I made straight A's in college. I made 1B in a creative writing class, which is kind of ironic. And so with that profile,
have you ever thought about being an overachiever though? Have you ever considered being an?
I mean, yeah, I was just competitive.
Oh, good.
I was halfway through college when I realized, hey, I still have a 4.0. I should just try and keep this up.
Yeah, absolutely. All right. So the school.
So I applied to a bunch of colleges, and I had gotten my results back from most of them by January, and that's when fall semester ended, winter break, and I was going to check my mail one last time before I went home. And I went to my mailbox and I found this big glossy acceptance package from New York University School of Law, which was ranked number 4 in the United States at the time. And so I knew right then and there, I was like, this is where I'm going. I'm moving to the big city. And I'd never left the South before. I'd never been to Manhattan before. I just knew when I opened it that that's where I was going. And I got into UT. I'd gotten into University of Virginia, a bunch of really good programs. But that one was far and away the most elite school. And they're still a top 10 in the world law school. And I certainly paid a lot to go there. But it was the most challenging experience of my life. World-class faculty, all of my colleagues there, all my peers there were just brilliant. And whether they were background in sciences or the humanities like me, just some of the smartest people I'd ever been around. And it was like trying to drink from a fire hydrant for 3 years. It's a very challenging experience. But I became worldly then. That's when I realized, wow, there's a whole bigger world out there. It happens when you move to the crossroads of the world in New York City and you're exposed to all that.
So, all right. So I know once a school becomes elite, of course, the best and the brightest want to go. But what do you think differentiates an elite school from a good school? Because I would assume if you're a law school that you're at least considered a good school.
I think the biggest difference between the upper echelon of law schools is that the authors of the case books that are used at all the law schools in the country, those authors are faculty at the top ranked schools. So I'm a tort lawyer, right? That's what I do now. I sue tortfeasors. Those are my defendants. They committed a tort and they hurt my client. The torts law casebook is written by Richard Epstein. Richard Epstein was my torts professor. So I sat in his classroom, the guy that literally wrote the book on this. My civil procedure faculty member was Helen Hirschkopf, and she was one of the authors on our civil procedure book that's used nationwide. So we're getting it from the source. So cutting edge information, cutting edge research, but also when they tell you what the law is, you can take that to the bank. No one in the world knows with more confidence than that professor what the law is or what it should be. So it definitely inspires confidence.
So okay, and you just use a term that I think a lot of people aren't familiar with, tort. Do you have a definition of tort? Do you have your preferred definition?
I mean, we'll look to the Black's Law Dictionary
and Black's
definition of tort.
And just so the people know, Black's Law Dictionary, if you are confused about a word, that is a dictionary that you can get as a layperson, but typically your attorney has it and accesses it multiple times. But go ahead. You say, what's Black's Law Dictionary definition of tort?
So I'll give you the technical definition. A tort is a civil wrong, so not a criminal wrong, a civil wrong, so other than a breach of contract.
I didn't mean to interrupt you, but matter of fact, let me let you get into it because you keep saying things that I know most people aren't familiar with. The difference between civil and criminal is civil is just a preponderance of the evidence.
Well, there's many differences, and that is one of them. Is when you're proving a civil offense, you have to prove it by a preponderance of the evidence. Whereas when the state is trying to prove a criminal offense, they have to prove it beyond a reasonable doubt. It's a higher burden of proof in the rules of evidence. But in general, the distinction between civil litigation and criminal litigation, civil litigation results in a monetary or equitable relief. So either a money judgment or an injunction, whereas a criminal case results in either a conviction or an acquittal. And if you're convicted, you lose your liberty. So it's not just a money judgment. It's now you go to jail, you go to prison. So that's the big difference between civil and criminal, generally speaking, between private citizens and business disputes. You're in civil law, and I'm a civil attorney. I don't do criminal defense or anything. So, but yeah, Black's Law Dictionary definition of a tort is a civil wrong other than a breach of contract for which a remedy may be obtained, usually in the form of damages. It's a breach of duty that the law imposes on persons. So basically, when there's a duty that is breached that causes damages, duty, breach, causation, damages, those are the elements of a tort. So we all have a duty to act reasonably toward each other. Sometimes we have duties that are imposed by law, and you have a duty to protect foreseeable victims from the consequences of your own irrational behavior, right? And so if you're going to go and start shooting a gun off in a crowded downtown area, you're committing torts. If you drive your car into the wrong side of the road and you hit somebody, you've committed a tort. And then there's a sort of hybrid con tort where it's sort of a breach of a contract that also was a tort because the duty that you're breaching arose from that contract, but there's some extra behavior or other duties that are breached.
That's a new term. So, that's a new term for me, con tort. Yeah, great.
Bad faith litigation is sort of like a con tort, but in general, I look at myself as a tort lawyer because my clients are victims. They've been hurt by somebody who had a duty to them, and that defendant breached their duty to my client, and I'm going to go and try and get them money in order to compensate them for that.
Okay, so you passed the LSAT, 97 percentile, Mensa grade. You make it to an elite school, and the difference between elite and good is your professors actually author some of the, I guess they're considered the Damn, what's the word?
World-class experts. They're the
Absolutely.
authorities who they clerked at the Supreme Court of the United States. So they know the Supreme Court justices personally. Or they clerked at the appellate level, which is the next rung down the ladder from the Supreme Court. So that's what you get in your composition of your faculty members at those elite law schools.
Mm-hmm. Got
After law school, I sat for the New York bar because I was in New York and I wanted to work there. And it's the oldest bar in the country, and it just felt like the right thing to do, and to continue to work in New England. And that's allegedly the hardest bar exam in the country. I think that there's probably 5 extremely difficult bar exams in the country, and then the rest of them are just very difficult.
Got it.
You know, there's no easy bar exam. Let me be clear. They are all very difficult. I think the reason why New York has a reputation for being so hard is because it's spread out over multiple days, and because the number of different subjects that they can test you on is so high. So you just have to know all these different areas of law to prepare. But 7 years after law school, I sat for the Texas bar exam because my roots are there, and it was inevitable that I would end up having a lot of potential clients in Texas because of my personal ties to that state. So I could either try and wave in after a few more years, or I could just bite the bullet and sit for the bar again. And because the work I did in nonprofit environmental advocacy and as in-house counsel didn't count towards the waving in threshold in the Texas bar. So I would have had to wait for too many years. And the last few years of my career have been really productive, mostly because of my connections to Texas. And so I think it was ultimately well worth it to be admitted there and to be able to serve those clients. And the Texas bar is no joke. That was also spread across multiple days and was extremely taxing. And partly because I'd been out of law school for so long, and some of the things that they're testing you on, you don't actually encounter in the real world. Those are law school subjects that are covered in law school. So I had to go back and brush up on all of that. It was probably good. It was probably good to do that, just to really kind of rekindle my love for law as a student of the law.
Yeah, rekindle, reinforce. So,
Exactly.
All right. So that actually, all right. So first, let me ask you this. During college, were you in any fraternities?
Yes, I was. In fact, I was the president of my chapter of Sigma Phi Epsilon, or Sig Ep. And let me be clear, because there's a very different world of fraternities at some colleges. What we had at TCU, 40% of the campus is Greek. 40% of the campus is in some of their NCAA athletic program. So the vast majority of students at TCU are either in sports or they're in the Greek life. And Sig Ep, when I was at that chapter, was finishing in the top of the school in terms of GPA average, our manpower, just in terms of our membership, and our service to the university, and athletics. So we were striving to live the balanced man ideal. That is actually the motto of the Sig Eps. And so I was elected president as a sophomore. Actually, I ran unopposed. It was a really special time. And it was just par for the course for me, because I would be a lifeguard and watching the pool when everyone else is swimming and having fun. That's just kind of how I am. And so to be president of that chapter, so I can kind of watch over it, manage the risk, and hopefully everyone has a good time, but they get what they're really there for, which is an education and to make good brothers, friends that has a spiritual and a moral component to it. And that was a really great structure to my experience at TCU. Although I'd say a lot of my really good friends from school were outside of the fraternity. There are people I met outside of the chapter and the other programs, my friends from the theater program, my friends from the business school, and so forth.
So what? And the reason why I asked is, was there a difference for admittance? Could somebody join your fraternity with the term that I heard, a paper, like a paper member, like just sign a form and then you're a member, or you had to go through a process? No. Okay.
It was a recruitment-based process.
Got it.
Yeah. And so I was, the gentleman that recruited me, Matt Friedman, he's a legend at TCU. He had really turned that chapter, taken it to the next level, put him into the top 3 in those categories. He ended up being a triple major, English, biology, and chemistry, and he graduated with a 4.0. So he was a junior, and I was an incoming freshman. He recruited me, and he basically tapped me to be the future leader of the chapter. And he just saw something in me in terms of my work ethic and my intellect that he wanted to be part of that chapter. And so he recruited me, and that's made all the difference.
Got it. Cause all right. So, cause there are some fraternities and sororities where if you pay the right fee and sign the right paper, you can call yourself a member of that fraternity or sorority. Have you ever heard of that?
Yeah, but that's not how it worked at TCU. Their Greek life has actually a pretty elaborate recruitment process, the rush process, the summer before you matriculate, and they look at inbound candidates. They meet with you, they socialize with you, they kind of see what your career goals are and kind of how you like to socialize, and you end up falling in with one of them. But you have to get recruited. There's a recruitment committee, and they have to actually extend you an offer in order to get in. So you can't just buy your way in.
Got it. Because the reason why I asked, man, because when I heard of this thing that I'm about to ask you about, I looked at it like that. I said, I wonder if the existing members would consider this cheating, or would they high five you for using your words, your innovative creatism? Like, so there are four states, right? You know where I'm going, that allow you to take the bar without going to law school. How do existing attorneys feel about that? Or do y'all like, all right, if you can do it, do it? Are you like, you didn't go through Rush Week like I did. You didn't go through the taxing stuff like I did.
Yeah, no, that's a good question. Fair enough, too. I think that if you can pass the bar exam, welcome to the practice of law. I think that going to a 3-year Juris Doctorate program, that's kind of the gold standard. It's I found it to be extraordinarily valuable in shaping my intellect and my approach to problems, and it filters out those who are not tenacious and disciplined enough to be a good lawyer. And so that's one thing I would worry about, is if you relax the standards for admission, you end up with people practicing law that they just you shouldn't trust them with your case because they don't have the follow through. And so that's not necessarily the as advertised purpose of law school, but it's a practical effect of creating that barrier to entry as well as the bar exam. But I just find it hard to pass the bar exam if you haven't been studying the law for years.
Mm-hmm.
You can't fake it. You can't cram for the bar. I'm sorry. You got to stack 1.5 feet high of text of laws that they can test you about. You can't cram for that. So if you can pass the bar exam without going to law school because you had a mentor attorney and you spend a bunch of time in the law library or just reading at home, more power to you. I think in many ways with the bar exam, another practical effect of it, it's not as advertised what it's testing for, but it's testing to see whether you have the discipline and the ability to sacrifice yourself for at least 2 months of no personal life, drop everything you're doing, and wrap your brain around this massive problem that is bigger than anyone. You know, it's so hard to ace the bar exam. Like the average passing score is just a few points over failure. Okay.
Yeah.
It's a hard exam. And that's sort of a minimum competency exam. It's a few points over failure is the average passing score. So it's a question of, do you have the desire? Do you have what it takes? Do you have the ability to stop what you're doing and put everything into this case? Because when you're practicing law, sometimes that's what it takes. When you go to trial, a lot of trial attorneys will lose weight in the month before their big day. They can't even eat. They're so caught up in their case. They're studying at night. They're working through the weekends. I mean, it's not necessarily healthy, but those are the kind of things that surgeons do. Those are the kind of things that lawyers have to do. Executives at a high level, they have to do that. And the bar exam, you basically can't pass it unless you did that for a couple months.
Okay, I like how you answered that, because even to the trained ear, I still don't know where you stand on it. You're a great attorney. All right, but that's good. But usually by the time you encounter business owners, you're reviewing an insurance policy they purchased. So would you say typically for companies, is it the standard business owner's policy, or do they normally go different? Do you normally see different?
Well, there are different kinds of insurance policies for different types of risks that you want to manage. Most business owners have a BOP policy, sort of a general premises liability, professional liability. If you've got employees that are driving around, they get in an accident, that's kind of what's implicated there. If somebody comes in and steals your computers or your sprinklers go off and shuts you down, that's usually, or if a client sues you, then you would want to have directors and officers.
And BOB is
insurance.
usually considered the economical route for small business owners. Would you agree?
Yes. Yes. You just get your standard BOP policy and you go to business. I definitely don't recommend being a business owner with no insurance. You got to have some coverage. Your bank might force you to have coverage. But the property, it's the P&C policy that I'm looking at more often than not. We sue for property damage. And so you want to have a property and casualty policy if you have any kind of large physical assets that are exposed to casualty risk, like hail, fire, windstorms, theft, those kind of physical assets you want to have properly insured. And we're looking at, do you have adequate coverage? Is your deductible reasonable? Do you have any nasty exclusions that you might not have expected or that you can't live with? And it's best to have your insurance policy reviewed by an attorney, because sometimes the brokers struggle to adequately explain and educate their consumers, and they're just selling them on the lowest price premium. And oftentimes you get what you pay for with insurance, and you end up, and so never ask your broker, give me the cheapest policy, because there's nothing more expensive than cheap insurance when that risk arises.
Yeah.
So if you're asking for the lowest premium, you're going to get a super high deductible. So when the risk happens, you end up paying for it yourself, and you're like, why did I have insurance if it's under my deductible? And you're going to end up with some nasty exclusions, or they're going to have some forum selection clause that forces you to go into arbitration in New York City, and you're like, I live in Tampa, this makes no sense. So get good insurance, and if you don't know, if you can't trust your broker for that, consult with an attorney.
And I wouldn't even call it mistrust. It's really in my opinion, it sometimes comes across as willful ignorance, right? So I wouldn't even say, because usually people go with agents that they know personally. So don't look at it as you don't trust this person, but just look at it as this person may be ignorant to it. And ignorance isn't a terrible word. I'm ignorant to building a NASA rocket, but that don't make me any less of a person, right? So what type of attorney should these people who hold, because I know a lot of people starting out will have that BOP, and a lot of people who are dealing with a lot more risk might have that property and casualty. What type of attorney are they taking their insurance policy to get reviewed?
Well, you should go to a first-party attorney, which means I represent the person that's named by the insurance policy. First-party property and casualty insurance litigator. That's technically what you want to look for. Although the insurance policy is a contract, it's a unique type of contract with a unique body of law behind it and interpreting it. And so a general contracts lawyer isn't necessarily the best bet. And not to cast any shade on them, but again, what I said about specializing, you want to talk to somebody who specializes in suing insurance companies,
Mm-hmm.
because that's what happens when they don't pay. And they're going to know better than any other attorney what these policies mean. And what I found is oftentimes an unfortunate situation is an HOA or a business owner will have their cousin, who's an attorney, handle their insurance claim.
Mm-hmm.
And it turns out their cousin's a divorce attorney.
Yeah.
Or they're just general counsel. They're not actually a litigator, so they don't know the judges.
Some horror stories,
or they don't.
man.
They're not.
Yeah,
They're not. Yeah, and the claim value
you
goes
and
to
I
zero.
have heard some horror stories of people hiring attorneys that, family members that do not deal with insurance claims, man, and
Right.
man, it can completely devastate a claim. It can.
Right. Yeah. I mean, you have to know your rights. You have to, in order to assert them, and sometimes that requires going through some procedures. It requires using the magic words. And if you don't go through the right procedures, you don't phrase things right, then you end up defeating yourself in your own litigation. So talk to a specialist. That's all I could say about that. That's the first place to go.
When did you write your first book?
That was probably published in 2013. It was a textbook for business students on sustainability. It's called Foundations of Sustainable Business, Theory, Function, and Strategy. And it's since been revised, and all new examples, all refreshed statistics. It's in its second edition. It's published by Wiley, the oldest publisher in America.
And how many books have you written?
3 now. I wrote another one with Business Expert Press on the role of the role of compliance in supply chains, operations, and marketing. So it's really sort of a compliance guide surveying federal laws. But the most recent, the third book, is called The Humachine, Humankind, Machines, and the Future of Enterprise. And that's about artificial intelligence and business strategy. And that was published by Routledge, an imprint of Taylor and Francis, which is the oldest publisher in Europe.
Okay. And the benefit of going through these established publishers and not self-publishing, because I'm assuming going through these established publishers, they're going to get their percentage. But going through self-publishing, you keep 100%. What benefit have you found from not self-publishing, but going through these establishments?
Well, the main benefit is that I don't think that anyone publishes a book for the money.
Oh, really?
Yeah. Nobody's making money off of books unless you're already famous and you're paying thousands of dollars a month to a publicist, in which case you're just buying the sales.
Yeah.
I mean, it's, that's not why I write the books. It's to crystallize hard-earned knowledge and to convey it in a way that's digestible and actionable for other people, so that I can be like a torch that's lighting other torches. That's the reason I write the books, and they have hopefully a long-term impact by opening the reader's minds, giving the reader tools and a vocabulary that they can take with them into their careers and into their lives, and have more power and more influence in a good way. And to take the wisdom from a book and to live it is to increase the amount of wisdom in the world. So that's the reason why I write. So the reason why you would go with an established publisher, if you can, because they have to accept you and give you a contract, is because of the credibility, but also the quality. If it's a good publishing house, they're going to have really good editorial staff in-house. They're going to do all the formatting correctly. Their print quality is going to be good. You're going to get better cover art. You're going to have more better existing distribution channels. And there's no harm. There's nothing wrong with self-publishing, but there's just kind of a sea of information out there, and it's really hard to distinguish yourself if you're self-publishing. if you're just giving this away as sort of a funnel for your business, then that's a great option. But if you're trying to establish something from a more academic or scientific approach, which is what we're doing with these books, it's more like we're trying to create new knowledge. And that means you should be going through a publisher that has sort of more of a peer review process, getting subject matter experts to look at this and make sure it's valid. And there's just more credibility with that. I mean, like I said, Wiley and Taylor and Francis, they're the oldest publisher in the United States and in Europe, respectively. And those books have a bigger impact on the field. The AI book I wrote has, for whatever this is worth, it's garnered me several hundred followers on Twitter, and they are all law professors and computer scientists from around the world.
Now you're a subject matter expert.
Yeah, because I wrote the book on this, and they're reading it. They're like, I agree with his take. I agree with his perspective, and hopefully trying to share those ideas.
Hey man, it's so many questions I want to ask you, so many, and you're not fooling me. I know you said the schools are distinguished, or what's the word I use? The schools have prestige if the instructors have written books, and you're writing a bunch of books. I know what you're doing, man, and it's so much it's so much that I want to ask you, man. But I know, once again, I know your time is very valuable. So even though I want to keep asking you questions, I really do. I want to let you go. What last thoughts do you want to leave my audience with?
Well, I mean, this would be a chance to plug my law firm and to plug my books.
Oh,
but
yeah.
If you're interested in that, you can find it out. What I want to say is know thyself. It's the same thing that Socrates said. If you really want to succeed as a business owner, you have to know yourself. You have to understand what you really care about. You have to understand what your strengths are and what your weaknesses are. And then you can build a team around you that leverages your strengths and that offsets your weaknesses. And then you can really succeed. To succeed, you have to play to your strengths. You can't go into a battlefield where you're mediocre at best. You have to know what you're good at and then cater to that. And you have to be willing to make changes in your life in order to succeed based on that accommodation. So know yourself. That's the first step to succeeding, so that you can actually figure out what you're good at, what you like doing, what you can get up in the morning and be passionate about. And that's ultimately why everyone should be a philosopher.
I was just about to say that, know thyself. That was that philosophy degree speaking right there. So once again, we have attorney and author and future ancillary addition to the next prestigious college, year 2032. John Wood, man, thank you so much for joining with me, man. I appreciate it, and I hope you be safe and have a good day.
Thank you, you too.
Absolutely. That was published author, attorney, and educator John Wood. John said, know thyself. What did John mean? Well, he told you what he meant. Let me expand on it when I hear that. When I hear someone say, know thyself, or when I think about the process and path that took me to know myself, the journey that I'm still on, I want to ask you, do you know yourself? A lot of you, I think, with a knee-jerk reaction will say, of course I know myself. But let me ask you, what makes up yourself? Would you say yourself is composed of your convictions, your viewpoints, your attitude towards people and situations? Would you say your convictions, your viewpoints, your attitudes toward people and situations determine how you act? And based off how you act on a consistent basis is who you are. Do you agree, disagree? Let's say you agree with that. Where did you get these viewpoints, these convictions, these attitudes? Where did you get your viewpoints toward religion, toward politics, toward certain people, groups, toward sets, toward everything? Where did you get these viewpoints? Did you come out the womb with thinking this way? I don't think so. I think that in your early years, your childhood years, you acquired these viewpoints, convictions, and attitudes over time from different people. Do you agree? Do you disagree? Let's say you agree that these are acquired. These are not your original ideas, but you acquired them in your early years. Some years more early than others, but you acquired them from outside sources that you picked up and you put on as your own, maybe from friends or family members. And I'm not saying any of these ideas that you acquired in your early years, or any or all of them, are wrong or bad. I'm just saying, can you at least admit that they are not originally yours? You picked them up, you acquired them. Okay, if you can admit that, I want you to also be willing to admit and commit to this. If you start the journey of knowing yourself, because if you agree that these were acquired ideas, now that you are where you are now, there is a chance that once you actually think and sit down and analyze your current life, your current situation, your current happiness level, once you sit down and analyze these things and you realize or reach the conclusion that A, you don't like your life right now, B, your happiness level isn't where you would like to have it. Once you sit down and do that and you start learning yourself and knowing yourself in order to get to that level of happiness, whatever happiness and success is for you, if once you start to learn yourself and know yourself, and something about your current self that you just learned conflicts with one of the ideas, convictions, viewpoints, attitudes you've had since you were a kid, I want you to be willing to drop that, regardless of what it is. Because just like anything else that you acquired, you can drop it. Just like you picked it up, you can sit it down. What about an outfit that you acquired? What happens when it becomes faded? What happens when it becomes out of style? What happens when it no longer fits you? You put it out. So just be willing to do that. And if you are one of the people who answered no to how I set up this, send this podcast to 3 of your friends and tell them to listen to the questions that I ask at the end of this podcast and see if they agree and disagree. People that you trust. And if they agree, I want you to at least consider what I'm saying is right. You can reach me on my social media, Instagram, Twitter, at RandolphCHFC. That's RandolphCHFC. If you're an entrepreneur podcast, you want to be on the show, send me your bio. If you wish I would have asked a question that I didn't get around to asking, send me that too. Hey, I'm trying to grow, trying to get better at my skill, my craft. This is the Entreprenudist Podcast.
Gotta make another couple $100,000 a month. No, I can do it, I just gotta stand a hunt. Grab some snacks and some fluids and a couple hands of blunts. I play through the fourth quarter, I don't plan to punt. Gotta make another couple $100,000 a month. Watch me. No, I can do it, I just gotta stand snacks and some